Oh, you're going to help me. No. All right, can everyone hear me?
Yes.
All right, perfect. I like the energy over here. So many people. Yeah, yeah. You know, like when we first ran these tutorials, like last year, like we were like getting like 1-2 people, like so it's just me talking to myself, and then we have like 2 full tables, 2 full benches. When you do multi in the future, you call that bench or something. I don't know what it's called, but anyway, yeah. So basically, oh yeah, you're just right in time. So today we're going to look at extension of where we started off last week. Last week we talked about introduction to criminal law, what is a crime. We'll look at 2 cases, Crown and Brown, as well as all the legal philosophies. Today, basically what we're going to look at is, again, we're going to do some review, but after we're going to talk about the idea of why punishment, i.e. like what the sentencing act says, why do you want to punish someone, what's the reasons behind doing so. And also we're going to look at the elements of a crime. I see that there's like, how many people on Zoom? 5 people on Zoom? Yeah, we can. Yeah, I think we can all hear me. If there's any issues on Zoom as well, just shoot me a text in the chat. I will be able to hear you guys. I mean, read it. I can't hear Zoom. But anyway, so one other thing I want to start off, just some admin issues. Is that we do have materials from the LSS as well. So these are not basically from your Moodle. This is a separate resource, pretty much like tutoring when you guys are here. So go into your LSS websites under LLD education, and you should get your membership by now, $15. And basically search for education and search for criminal law 1. There will be sketch notes and problem questions. So the sketch notes are basically like a summary of what you're going to get in the actual exam, and the summary of the notes, and the practice questions are basically a stimulation of what you might have gotten in the practice exam. For me, at least, I'm trying to make this as similar as to your exams as possible, because there is very little resources available out there, I know, because I've been there in your exact position 2 years ago. So I do try my best, 20 or 15 multiple choice questions, 5 problem questions. The difference between multiple choice and problem question is that multiple choice basically get options. Problem questions, on the other hand, are what you're going to likely get for the rest of your law degree. You're going to get a lot of basically scenarios, and you're going to advise your clients. So I hope this could help as well. And if there's any issues, feel free to shoot me a text as well, ideally via email. If you shoot me on Messenger, I take a long time to reply, but I will try my best. So that's one, and the next one is, all right. Any issues with accessing the notes? Once I do see some notes available from this table, which is good. Any issues, anyone? We all got the notes and stuff? Yeah? All right. I do upload my slides. I try to upload them now every time before the lesson as well, or if I could, like even one day before, because I know it would be nice to have something to refer to. The slides are uploaded on the Facebook group, and there are recordings for these classes as well. The recordings are under the LSS website, YouTube channel. Not my YouTube channel, please don't go to mine, but the LSS YouTube channel, okay? So, but yeah, you're welcome to subscribe to my own YouTube channel as well. Anyway, so we're going to look at this idea of why punishment. So I just want you to get a big picture of what you are learning in the 2 hours before you actually even started your actual class in lecture. In a sense, I spoke to your chief examiner last Friday or so, and I believe sometimes this week your Moodle should be up for criminal law, or has it been up? I'm not too sure. Up already? Yeah, that's good. So basically, you will get this. You will be able to see reading guides, and then you're going to be able to see the modes of assessment, summary, everything. So I'm pretty much covering all the introductory nature kind of questions regarding assessments and stuff. So for example, last week we looked at introduction. Under the sketch notes, you'll also see there's quite a fair bit of information on that. When we look at why punishment, we're focusing a lot on your assessment tool in the sense where you are doing this 20%, where you're going to advocate for your clients, you're going to participate in more calls of stuff, and you need to have some justifications of why you are, say, punishing certain person. Say you committed a crime. Do I fine you $500 or do I send you to prison for like 2 days or something? Like why? What's the reason behind it? So you could theoretically make some arguments, but you need to understand why you do so. So that's what we talk about. In Foundations of Law, you're also going to learn how to find out about legislation, but pretty much you could just key this to Google and Google will tell you what the Sentencing Act is. You will learn how to research legislation more in depth in Foundation of Law. But basically, our starting idea, and this, if you do have the reading guide along with you from the faculty, that would be good as well. But anyway, the reason behind there's quite a fair bit of reasons. And we get these reasons from the legislation. These are what we call primary sources. Another form of primary source is what we call case law. So statute and the case law. So under section 5, basically they tell us that there's quite a fair bit of reasons. Oops. Okay. So if we see over here, they say, okay, to punish the offender, that could be one because perhaps you commit a crime, you want to get some sort of punishment to deter the person from repeating similar offenses again. So for example, if you cheated in your Foundations of Law quiz, and then you get like a suspension, that's too much. Maybe you cheated in your Foundations of Law quiz and you get an email from the chief examiner and state that you get a 0 for your assessment. Yeah, it's just to deter you from future offenses again. To establish condition within which to establish conditions for rehabilitation. So if the court thinks that, okay, you are a good person, and I think we can save you, then maybe we will rehabilitate you. Or perhaps to manifest denunciation. For example, again, if you cheated in your Foundations of Law exam and you got a 0, what the chief examiner essentially saying is that, no, this is bad, and we denounce you, okay? And we could also protect the community from the offender. So this is more like a scenario where, say, for example, there was a murder in your neighborhood or something, in your suburb, and that murderer basically got caught in prison, starving for life in prison. Right, the reason is to protect the community. So there's quite a fair bit of reasons. In your exam, later on when you write the assessments and stuff, you do want to point back to section 5.1 of the Sentencing Act as well. This will be quite an important issue. A lot of students, especially when they first started law, what they do is they just use their own ideas and they expect to get like 20 out of 20 and it doesn't work, okay? So, other combination of 2 or more. Another thing that you might see in your reading guide is this role of public prosecutor. Say, for example, today, in this class, I took a knife and I stabbed everyone over here. Who is going to sue me? Your parents? Silver medal? Who? Yeah, the DVP, the public prosecutor. Your parents can't sue me in this case in the sense it's not a silver medal. If say, for example, I owe you like $1 million, maybe, I don't know, I cheated you $1 million or something, then your parents will be able to sue me. But in this case, we're looking at the DPP. So they are essentially prosecuting people for criminal matters. So for example, last week we looked at Crown and Brown, that is basically a public prosecutor. So you kind of want to know the roles as well for a public prosecutor. And under your reading guide, I pretty much took out what section 14 is. I'm just going to say a few examples. So for example, what are the roles of the prosecutors? You want to act independently, act fairly, act impartially, assist the courts in cases of error. There's quite a variety of things. I'm not here to read the slides or anything, but basically directing you to where you might want to find some of these resources. So thinking about the role of public prosecutor will be quite important as well. So in your assessment, you're going to again get defendant or the prosecutor. If you get the prosecutor, because I think you get in Paris or something like that, if you do get a prosecutor, do make sure you point out something about the role of public prosecutor to back up your claims as well, instead of just making unsubstantiated judgments, which is not good. So there's also other sentencing options. Again, I took this from the reading guide. So under Sentencing Act 1991, you could have dismissal, you could have fines, community correction orders, custodial sentences, etc. So there are quite a bit of examples over here. Again, we are not really able to cover everything in depth, and also just a study tip, like if you listen to me reading section 76, section 72, section 75, at the end of the day, nothing goes into your mind. I think maybe you do, but at least if I hear someone read out the legislation from chapter 1 to 1000, and at the end of the day, I'm like, that's a good app. So what I'm going to leave you guys to do is, in your own time, look at these, read the sections. These will be kind of your homework, all right? So today we're just going a little bit fast. Also, I see someone's on Zoom. Is there a recording from last week? Yes, Isabella, there was a recording. So it's on YouTube from LSS website. Okay, so you can access there. Any questions so far? No? All good? Yeah. All right, so bearing in mind two things. So one was the role of the DPP just now, and also we looked at the section 5, subsection 1 of the Sentencing Act. Now we want to consider a scenario and ask ourselves what sentencing principles should apply over here. So last week, remember what we did was we did multiple choice questions. That is one form of assessment in law school. We have another thing called problem questions, and this is what a problem question is like. It's like a scenario where you're supposed to advise your clients. So you're going to get these kind of questions all the way from year 1 to whatever year you study. 5, 6, 7, 4, 3, I don't know. But yeah, you're going to get very bored of this kind of problem questions. So anyway, right now we are pretty fresh. So let's read through this scenario. I'm just going to give the class 5 minutes, and we're going to discuss in 5 minutes time. So that will be 2:23. All right. Read the scenario and we'll discuss in 5 minutes time.
But it was within 5 business days. But I just supposed to be like.
Not started yet.
And like, what do you want?
Um. All right, are we ready, everyone? So who wants to get started? What sentencing principles should apply? Perhaps, do you guys want me to stay on this slide, or maybe we can go to this slide? Or what I suggest, put this slide on your laptop and we look at the practice questions. Yeah, so, yeah, who wants to get us started? Yeah, go ahead. Tell me your name as well. I'm very bad at names, but just tell me. Yanni?
Yeah.
Yeah, okay, tell us, yeah.
In this case, I would just say like a short term of imprisonment.
Short term of imprisonment.
Yeah.
Okay, you think this student is very dangerous?
Yeah, I mean, the teacher's bleeding and locked him up as well.
Oh goodness, all right. Okay, so you think it's quite serious as well, all right, good. Yeah, so you point out imprisonment. Was it community protection? I think from the legislation, they call it community protection. That's the reason. So you basically, you put like you put a topic sentence, be like, I think community protection should be the priority here, and you explain why that's the case. You'd be like, this is a very serious issue. People are being injured. Ambulance came, police arrived. It's not just a normal fight in the bar where you get people making arguments and be like, hey, want to fight me? Hey, I'm good. It's like this kind of actual punches and stuff. And then you point out to some evidence. You can quote this question, and then you conclude, and you write another paragraph basically from there. Anyone else who thinks that's too harsh? Come, defense.
Like, no, it's obviously a one-off thing. He probably broke under like pressure. He's a threat to society. Like, you don't see him as like, this is how he's gonna do this again and again and again. Like, he's not actually killing everyone, So it's like rehabilitation because he's obviously, he has a bright future ahead.
Our bright future ahead of him. All right.
Hopefully, if he like,
Yeah.
hopefully, if he like, if he like he gets the right help and not just like going to prison with no support. If he's not like he's gonna follow that line, that pathway, but if you give him some support, like he's obviously struggling with like issues. It's not just like doing it for fun, like not punching people for fun,
Yeah. Yep. So not just punching people for fun. So he's punching people for rehabilitation. All right, here we go. One more. And Yan and
Oh, brilliant.
William, yes.
I was just gonna say, yeah, I definitely would agree with what Han said, but there's just that one sentence and it says Daniel pleads not guilty despite clear evidence of the incident. And I thought, well, if that's the case, it kind of means that he's got really no remorse for what he did. So I think there definitely should be some sort of punishment to the offender as well.
So what's the penalty?
To punish the offender.
Good.
My name is Leon. I agree with what Will said, but I think it should be on the principle of rehabilitation. But I think they should impose a CCO, because even though like it doesn't show any remorse, we should still rehabilitate him. Maybe you impose a harsher sentence of rehabilitation, like more hours, because he's 18 years old, 99.95. He has a good future in front of him, right? And so you want to like lock him up, go in prison, because then that's just gonna make it's gonna do also rehabilitation. So yeah.
Good, good. So what do we have over here at the end of the day? Two-person arguing for like more like the prosecutor side, two-person arguing more for the defense. So who's right, who's wrong? Well, everyone's right. So, but the argument is that again, this kind of problem question is written in the style of an exam. So you're going to get like 3 to 4 scenarios to choose from, and you're going to get paired up with one person or another student, and one of you will be defense, one of you will be prosecutor. So you can see that from this kind of problem scenario, you will get arguments from both sides. You will see arguments on one hand when you say, oh, he has a bright future. 99.95 ATAR, not a lot of people. Who here has 99.95 ATAR? No one. Oh goodness. Receive a fully funded scholarship. Who has a fully funded scholarship? No one. Yeah, someone can argue. Oh, maybe you do? You don't.
No, I said I could never.
You could never. Yeah, so you could point this as you could point out that as like arguments for defense. But then you could see that, oh my goodness, he's charged under section 16 of the Crime Act. This thing here gets punished like 10 years imprisonment maximum. So it's quite a huge serious offense. Quite a number of bleeding. Oh goodness. Ambulance have to come. Please not guilty despite clear evidence. So this could point for the prosecutor side. So you could make arguments both ways. Again, that's what a normal student would do. So what would the best student do? Like, balance, good, right. So how would the credit answer would do? Credit answer would be like, oh yeah, look, this guy very smart, 99.95 I think he has a bright future. He has a fully funded scholarship. Therefore, I think he should not go to prison. You get the credit for that answer. The reason is because like everyone's going to write that. Like we are all reasonable minds who are able to think about these kind of things. Even ChatGPT does a better job than that. So you kind of want balance. You'll be like, maybe you're the defense. You'll be like, okay, yeah, he has 99.95 ATAR. So what? Like this scenario has nothing to do with how smart he is. The idea that maybe there was a significant amount of blood and clear lack of remorse suggests otherwise. And you could point out maybe he could use his intelligence to cause more harm to the world, whatever nonsense you could think of. Make that kind of argument and balance and acknowledge both sides. And that's how you are able to do very good. Okay. I was telling that table over there, how last year students who appeared in my class at the end a lot of them were telling me they got in the 85 to 90 range for criminal law. Think about that. I think for you to get the first class honors, I think it's 77 when. All right, and people are getting 85 to 90. So I think you're in good hands. If you do the techniques, okay. So anyway, I think I severely there is a question. Another question. Yep. So Faye says there wasn't any recordings. So yes, I will check on the recordings because currently I'm making it as an unlisted video. I don't know what the instructions from my boss are, but anyway, I will check and I'll make an update today. All right, so we are severely short of time, I believe. Yeah, because I'm very little experienced with this. But anyway, so we're going to move on. I'll see how much I can do. But if not, no, we might need to push this something next week. But anyway, we're going to look at elements of a crime now. This is basically, who here still remembers what kind of definition we talk about crime? What is a crime? Who still remembers the definition? And yeah, go ahead. Tell us the name as well. Sabina?
It's something that, well, we're talking about criminal law.
Yeah,
And we're
what's
saying that it's used to help regulate behavior in society.
body of law to regulate behavior, society, great punishments for certain sort of offense, kind of along those ways. So when it comes to a crime, what we're looking at is we need to determine what exactly is a crime. Say, for example, today, maybe I was not really happy. I looked at your eyes and I stared at you for 10 seconds. I looked at Will's eyes and is that a crime? Versus, for example, I came after you. Goodness, okay, I won't, that's too far. I came after you, and you were like, "Ooh, is that a crime?" Right? Or maybe I was in the case of Daniel, I threw a punch at the chief examiner of Foundations of Law for failing my exam. Would that be a crime? So what exactly constitutes a crime? We need to look at this fundamental principle. This Latin phrase, goodness, I can't pronounce it. Yeah, but this Latin phrase that says, who can help me pronounce that? Come on. Yeah, good. All right, I don't usually know. I'm pretty sure a lecturer can because he doing it for 20 years, but I'm just very not good at this. So what this means, are we all familiar with this idea of actus reus and mens rea? Or not too sure, somewhat? Yeah, so when it comes to a crime, goodness, is there a marker? Yes, there's a marker over here. When it comes to a crime, we have two elements. We have the AR element and the MR element. So AR stands for actus reus, and you have the mens rea. So when we look at actus reus, we're essentially looking at the physical actions. Alright. So for example, when I stare at Will, the actus reus is me staring at you. Or when I walk up to you just now, I hope that didn't make you uncomfortable. But anyway, when I walk so up close to like one of you up there and be like, you want to fight? Whatever kind of things. That is the actus reus. Okay. Now we look at mens rea. Who here want to guess what mens rea is? Yeah, go ahead.
Like the state of mind.
The state of mind, yes. So for example, how would you describe my state of mind when I stared at you just now? Anger. Hey? Alright. Am I that mean? No. So we look at the state of mind. So what I was looking for was intention. I intentionally did it to bring an example or illustration. So for you to have a crime, basically this definition over here, this Latin phrase tells us that, we have multiple choice. Which one? Want to take a guess? A? Yeah. So an act is not guilty unless the mind is guilty. That's the Latin maxim. So for you to have a crime, you need to have the AR and the MR happening at the same time. Okay. So then we think about it. There are something like traffic offenses. Say for example, today I went out to the Wellington Road and then I just drove past that red light camera. Maybe I wasn't aware. Maybe I was just so happy that we were not stared in the eyes just now, and I'm not gay, by the way. Anyway, so yeah, I just lost my mind for whatever reason. All right, so and then I just drove past that traffic light and the speed camera flashes. And then I got a $482 fine with 3 demerit points. That's why I'm broke. But anyway, then can I make an argument that no, I'm not guilty because my mind is not guilty. My mind was freezing around. Can I? No, you will still get punished. So then you see, okay, what about traffic offenses? Traffic offenses don't really fall in here. Yeah, precisely. There are certain sort of offenses that fall into this idea where we need AR and MR. But at the same time, we have to realize that certain offenses, such as traffic offenses, or we call them strict liability. Strict liability. As long as you do a certain sort of action, you'll get punished. What that means is that for that kind of offenses, we only need the AR. I.e., if you drove past a traffic light, you'll get a fine. We don't care about your mental state of mind. Obviously, you could go and appeal and stuff, but that's out of question for now. Okay, so I'm going to look at, so that's pretty much what we explained. Right, so actus reus suggests the physical element of a crime, and mens rea suggests the mental element of a crime. Okay, so to secure, if you read that sentence below, to secure most criminal convictions, you must not only prove that the accused committed the action of the crime, but also at a certain time he had a particular state of mind. And the word is most crimes. In your exams, at least for this year's criminal law, the topics are offenses against the person. So let me write this down. Offenses against the person, sexual offense. And what do we have? Homicide. So pretty much these 2 weeks, I'm just introducing you to everything, the introductory nature and stuff, the skills, the multiple choice, the prosecutor 20% assignment, everything like that. But in your final exam, you are going to look at these 3 things only. I don't know why I need 12 weeks to teach them, but I'll make a lot of revisions. But anyway, so yeah, sorry if I'm not going according to faculty, but basically, I will label these recordings for future references as well. So in an exam, how it might look like is you might get one question on offenses against the person for 20 marks. Maybe question 1 will be like, Will and I stare in the eyes of each other. And after the class, I wasn't happy with him. I told him to take me outside, and outside threw a punch at him. And he did certain sort of action. He followed me back home and realized where my address is. And because of that, they had some sort of argument. The ambulance came, 1 person suffered serious injury in the end. That would be under offenses against the person kind of question. They ask you discuss the criminal liability of Will and Sebastian, 20 marks. And you're going to list out stalking, causing injury seriously, causing injury recklessly, whatever kind of things. Then your part question 2 will come up something like, sorry, before that, then you will talk about AR and MR of each offense. You'll be like, oh, maybe there is stalking. What's the AR of stalking? Oh, the action of Will following me back home is stalking. AR is a field. You talk about MR. What's the mental state of mind? Oh, yeah, this person clearly has intention to follow me because maybe he wants to take things outside and find out about my history and stuff. MR is a field. Therefore, stalking is a field and stuff. And then you have sexual offense for the marks per exam. You'd be like, maybe, do you mind I keep using your name? That's okay? Yeah, all right. Maybe I get sued after this class, goodness. Now, then question 2 would be like, after throwing a punch and following Sebastian home, Will decided to go to a bar because it's a Friday night. And at the bar, he saw this really pretty girl, and he decided to do certain sort of actions that fall under sexual offense. And then basically, that would be 20 marks. Okay? And then question 3, usually in the exam, they'll have a big problem question. They'll be like, after that, the boyfriend of the girl got very unhappy and decided to take things with Will to a whole new level. And upon one Saturday midnight at 3 AM, he brought a knife and stabbed at Will. And as a result, there was the death of a very innocent person. Discuss criminal liability for homicide. Question.
Just in terms of like these 20 mark
Yes.
what is the average length expect of these responses?
Right. So for me, I write on average 60 marks exams. I write on average 10 pages. Okay, so I write on average 10 pages. I don't think I could show you in a sense, but very long. In a sense, as long as you go through the different elements, you should be fine. Because, for example, when we have 20 mark question on homicide, the structure is always the same. You start off with murder, talk about dangerous manslaughter by act, you talk about dangerous manslaughter by omission, and then you talk about defenses. And each of them you write about 1 page or so, that's 4 pages, right? And then after that, you do another question on offenses against the person. You talk about section 16, 17, 18, 19, 20, 21, 22, 24, talk about defenses, that's again 4 pages. You talk about sexual offense, you talk about rape, you talk about sexual assault, you talk about threat to commit a sexual offense, you talk about soliciting sex and what other kind of things, 20 marks. Yeah, so that's how. So AR and MR is the fundamental element for you to really link up to everything like that. All right, so in your reading guide, okay, do we have questions here? No questions, perfect. Yeah, in your reading guide, what we're going to do, we can't finish this today for sure, but I'm still playing some Kahoot quiz after this as well. So later on, we're going to break down each offense later on in the semester. For example, when we look at section 16, causing serious injury, we're looking at what is the AR. So for each offense, you'll be like, oh, AR, you must be voluntary, you must have causation, you must meet certain kind of issues. And then you're going to look at MR. What are the MR of each offense? So basically, it's like an overview map. And then you're going to bring case law, right? Say last week we looked at the case law of what was that? Crown and Brown, and we're going to see, okay, what's the principle of that? And then we're going to look at, say, Hallett, say, Blau, say, Google, like what are the principles of there, and the exam you basically quote. Okay. By the way, later on the semester, if you do want to do practice questions, you're free to do them, and I'm happy to check it for you as well, personally. Okay. I think doing the practice question is really important. A lot of students, especially criminal law students, they go to the 60-mark final exam, not having even done one exam. That's a big thing. Question? How many did I? Do you want to hear my year 1 answer or year 3 answer? year 1 answer about 3 full papers. Year 3, goodness, I probably shouldn't say. So anyway, so 3 full papers. First paper, you're going to get very bad results. You're going to run out of time. You're going to be like, am I supposed to write this? I didn't get this in the structure, whatever kind of things. You're going to miss a lot. You're going to get like 30 or 60. And then paper 2, you start to get kind of the idea around it. And by the 3rd paper, you should be hitting the 50 to 55 range. It's not hard, okay? I'm giving, it's okay. Like, you look at these essays and stuff, before me, the criminal law tutor got 60 or 60 for TOEFL exam. For me, for my fund, I could do very bad for my semester. You ask me to write research essay, I can get credit for you. But my final exam will pull up to a high distinction because all the time I can hit like above 50 for my final exam. It's just a technique. You do this and you do this and you just keep making sure that you hit the scope and the depth required of you. You'll be able to do really well. The reason why I used to do 3 full papers is because I wasn't that good at the skill. But once I crafted this skill, pretty much I could do 1 paper or 2 paper, and I can still hit that question.
They come with the mocking guide or just like an example response?
Ah, goodness. So think about criminal law, you don't get a lot of resources. You might get them in week 12. So there's a few things. Monash Law Drive is one of them. You could also look at the LSS website. When I post, I see if I'm allowed to post. If I'm allowed to post, I will post some of the past exams with sample answers and stuff that you can see. And really being able to know how the marks are broken down to is very important. That's why students who attended my classes last year, because they got a clear understanding of how the marks are broken down into, because if not, you go inside, you talk about the history, the social context of what is a crime and stuff. When they ask you discuss the criminal liability of Sebastian, you're going to get 0 marks, okay? The tutor's exam will be like, oh, very interesting discussion of the history and context, but not relevant, So these are all skills that you could use, not just for criminal law, but later on as well. So we're running a bit low, so I'm going to cover the rest, the cases and mental elements next week. But what I'm going to do is I'm going to do a very quick Kahoot quiz. All right, so let's do that together. Monash Law Drive. Yeah, I'll let you know in a bit. 1, 2.
Like, and it's so fun. It's like I use ways to like, it's not my god. You messed up the next step.
All right, just two questions. I'm too lazy to start the Kahoot, so we're going to do a mini. Not really a Kahoot. I'm going to change because today I only got two questions. Let's look at I'm not surprised if later on in the Zoom recording, it's just a couple of things with nothing. Apologies. But anyway, so yeah, so regarding this idea over here is that you might get certain kind of questions where you see the statement is correct, but then if you look at the question, it doesn't answer the question. So that's also a technical foundations of law as well in prepare. I doubt you're going to get any practice questions for foundations of law. You can create your own. And honestly, some of the questions you can ask ChatGPT to create for you as well. It might work, at least for me. So that's pretty much how we look at questions like this. Again, I'll probably make about 10 questions next week about the case law and also everything we've gotten so far this week. Next week probably is more of, I'm going to look at the 4 cases, the Blau, Heller, Google case about causation, AR, MR. And I'm going to do a revision, but after that, probably need about 30 minutes on this, or 20 to 30 minutes on 10 revision questions. Because I know multiple choice comes up and it's a big thing. I also just got a reply from your chief examiner, so I would have access to what your syllabus will be exactly for this year. I'm going to look at that as well. But anyway, next class will be exactly the same location, same time, same person. I hope you like it. But anyway, any questions before you end? No? If not, you're free to go. Bye-bye. Yeah, coming to you. All right, bye-bye.